You were bitten, you've got stitches, and the owner's already saying, the dog's never done that before. Their insurer hints you provoked it or were somewhere you shouldn't be, and you're not sure what actually proves negligence in a Maryland dog bite case. Hi, I'm Bobby Zirkin, a Maryland personal injury attorney, and I help victims hold dog owners accountable when careless choices lead to real injuries. In this video, I'll show you exactly what evidence moves the needle under Maryland law, how to counter the usual defenses, and how to document your medical care, scarring, and lost time so that your case stands up in court. So that you don't get blamed or brushed off, you build a clean record, avoid Maryland's contributory negligence traps, and put yourself in a position to recover what you are owed. What counts as negligence in a Maryland dog bite lawsuit? All right, let's get right to the core of this. If you were bitten by a dog in Maryland and you're thinking about a lawsuit, the one word you need to understand is negligence. In everyday terms, negligence just means someone doesn't act as carefully as they should have outside of the standard of care. But in Maryland dog bite cases, proving negligence isn't always as simple as it sounds. Today, I will walk you through exactly what you'll need to prove, how Maryland law looks at these cases, and some common situations that can make or break your claim. I'll also give you real-world examples so that you know what to expect if you ever have to bring or defend a case like this. Maryland's dog bite law, the basics. Let's start with the law. In Maryland, dog owners are held to something called strict liability if their dog bites someone while off of their property or running at large. This basically means that in many situations, the owner is responsible for the dog's actions, even if they tried to be careful. So it's important to understand in dog bite laws, there are really two ways of achieving liability or proving liability in a case. First is by negligence. And the General Assembly in Maryland some years ago changed the state law. And essentially now what has to happen is a plaintiff in a case alleges that the owner knew or should have known of the dog's vicious propensities or the propensity to commit the type of violence that was perpetrated on them. The old law was that the plaintiff had to prove that. They had to show some kind of evidence that the owners knew something about what their dog could do to them. That's not the case anymore. Following the enactment of the new state law, now it's up to the defendant to prove that they did not know if their dog had a vicious propensity. It seems like a small change, but it's actually quite significant. In every case, the jury will decide what the dog's propensity for violence was. It's no longer a matter of something that could be taken out of the province of the jury. That's one way. So negligence. The negligence standard is the owner of the dog knew or should have known of the vicious propensities of their dog before it perpetrated some violence on the plaintiff. And then there's the issue of running at large. Under the new state statute, if a dog is running at large, and that's undefined in the statute, but if a dog is running at large, the owner of the dog is strictly liable for all damages done while that dog is running at large. So the question is, what does it mean for a dog to be running at large? Because it's not defined in the statute, and it's not really defined in any prior cases. A recent case, Blitzer v. Bresky, which was actually handled by my law partner Josh Schmerling in this office, gave some teeth to the meaning of running at large. In that case, a dog had been confined in an area. It was fenced in, and it was a joint area between two townhouses. The dog was allowed to roam freely and running around. And the victim in that case opened up the gate to get into her side of the property. The dog ran out and bit her. And the court in that case, and then the appellate court, made the determination that under those circumstances, the dog was running at large. And just because it was on the property of the defendant, that it could still be determined to be running at large. The key was it free and unrestrained? And the answer was yes. And so whether the dog is on the property of the owner or off of the property of the owner, this new case, Blitzer v. Bresky, has made the determination that a dog can be determined to be running at large. It's really important because when in cases where a dog is in fact running at large, they are strictly liable for those damages, regardless of negligence. Now, there are some exceptions for things like tormenting the dog or teasing the dog or criminally trespassing on somebody's property. Under those circumstances, the defendant can get out because those are defenses. But for those three defenses, when the dog is running at large, the plaintiff will recover as a matter of law. So how do you actually prove negligence in one of these cases? Let's break it down step by step. First, proving the dog owner owed you a duty of care. Every dog owner in Maryland has a legal responsibility, a duty, to act in a way that keeps others safe from their dog. This sounds obvious, but it's the starting point for any case. So if you were walking on a sidewalk or visiting somebody's home or even working as a postal worker or delivery driver, the dog owner does owe you a basic duty to control their pet. They need to leash, fence, otherwise keep their dog from harming people. It doesn't matter if you're a stranger walking past or a neighbor stopping by. The law holds owners to a standard. Let me give you an example. Imagine you're at a friend's barbecue. Their dog is normally friendly, but today it's acting out, barking, growling, maybe nipping at people's ankles. Instead of putting the dog inside, your friend lets it keep running around. If that dog bites someone, the owner clearly didn't take reasonable steps to protect their guests. That's what we mean by a duty of care. It's about having a responsibility to individuals other than yourself. Number 2, showing the owner breached their duty. Now, it's not enough to say that somebody should have done something. You have to show that they actually failed to do what a reasonable person in their situation would do. In a Maryland dog bite case, this often comes down to the details. Was the dog off leash in a public area? Did the owner ignore clear signs that the dog was aggressive? Did they fail to fix a broken fence that allowed their dog to escape? Let's say you're jogging through your neighborhood park and a dog runs up and bites you. If the dog was off leash, even though the park has leash laws, that's a clear example of the owner breaching their duty. People have the right to expect dogs are leashed when the rules require it. And actually, under the new state law, that is strict liability. The dog is off leash, running around at large, and the owner is strictly liable for the injuries caused by the dog in that situation. Or picture this. Someone has a dog that barks and lunges at people walking by. Neighbors have complained. Maybe there have even been reports to animal control. Yet the owner keeps letting the dog roam the front yard without a barrier. If the dog bites someone, it's hard for the owner to argue they did everything they should have. That's another example of breaching the duty of care. Number 3, proving the owner's breach caused your injuries. Now let's talk about causation. Simply put, you need to show that the owner's mistake is what actually led to your injuries. This step is often where the details matter most. If you're bitten by a dog that was off leash or known to be dangerous, and the owner didn't take steps to prevent it, it's usually pretty clear their negligence caused your harm. But sometimes the owner or their insurance company will try to argue that something else caused your injuries. Maybe they say you startled the dog, or you were trespassing, or you ignored a beware of dog sign. In Maryland, if the owner can prove you provoked the dog or you were on private property illegally, that can defeat your case. Here's an example. Imagine you're delivering a package and you walk up to someone's front porch. Their dog is on the porch barking. If the owner opens the door without restraining the dog and it rushes out and bites you, the connection is obvious. The owner's actions directly led to your injury. But if you hopped a fence into a backyard marked with warning signs and then the dog bit you, the owner could argue that your own actions in trespassing caused the incident. So causation is about showing a straight line between the owner's carelessness and the injury that you suffer. 4th, demonstrating real damages. The next thing you have to prove in a Maryland dog bite lawsuit, and any lawsuit for that matter, is that you actually suffered harm or damages. That means more than just showing a bite happened. You need to demonstrate that you were physically hurt, emotionally distressed, or had other real loss. This could include medical bills for stitches, surgery, or infection treatment, lost wages if you couldn't work because of your injuries, permanent scarring or disfigurement, emotional trauma like fear of dogs or nightmares. Let me give you another real-world example. A client once came to me after being bitten by a neighbor's dog. She needed an ER visit, she needed stitches, she missed a week of work. The bite left a scar on her leg, a pretty big one, and she started having panic attacks anytime she saw a dog. In court, we were able to connect each of these damages directly to the bite. from her medical records to her pay stubs and even statements from her therapist. The point is, it's not enough to say, I got bitten. You have to show what it cost, both physically and financially and emotionally. Defenses the owner might use. If you're pursuing a dog bite case in Maryland, it helps to know how owners and their insurance companies might fight back. First, Maryland follows what's called contributory negligence. This is a very strict rule. If the owner can prove that you were even a little bit responsible for getting bitten, you might not get anything. For example, if you ignored the owner's warnings, teased the dog, or entered a clearly marked no trespassing area, the owner could argue that you contributed to what happened. Another common defense is the assumption of risk. If you clearly knew that the dog was dangerous, maybe there were warning signs, or the owner told you directly and you chose to approach anyway, they can try to argue assumption of the risk. It's typically not successful to argue assumption of the risk when there's a dangerous dog involved. Here's a practical example. Say you're at a friend's house and they warn you, my dog doesn't like strangers, please don't pet him. If you try to pet anyway and the dog bites you, the owner could try to argue that you assumed the risk, making it at least a little bit more difficult to claim negligence. This is why it's really important to document everything. Take photos of your injuries, get witness names, and keep any communication. The more proof you have, the harder it is for the insurance company to try and blame you for the bite that occurred. Real Maryland case examples. Let's make this even more real with a couple of Maryland stories. In one Baltimore case, a delivery driver sued after being bitten by a dog that was usually kept behind a fence. The owner had left the gate open, and the dog ran out to the sidewalk and bit the delivery man. Because the owner had failed to secure the fence, they were found strictly liable for the injuries caused by their dog. Their dog was running at large. Even though they argued the dog had never bitten anyone before, that was irrelevant in the case. Let me give you some tips to strengthen your case. If you or a loved one has been bitten by a dog in Maryland, here are a few tips that can help you navigate your case. First, get medical attention right away. Medical records are key pieces of evidence. Take clear photos of your injuries and where the incident happened. Ask for contact information from anyone who saw what happened. Write down everything you can remember, what the owner did or didn't do, what they said, the dog's behavior, any warnings, anything you can think of. Don't talk to the dog owner's insurance company without legal advice. They may try to call you. It's a bad idea to talk to insurance companies. Every detail matters. The more you can document, the stronger your case will be. When to call a dog bite attorney. Proving negligence in a Maryland dog bite lawsuit can be tricky. Insurance companies will look for any excuse to deny your claim or blame you for what happened. That's why having an experienced attorney on your side can make all of the difference in the world. A good lawyer can help gather the right evidence, deal with the insurance company, and make sure you don't miss out on compensation you deserve. The sooner you reach out, the better your chances of success. Today you learned exactly what it takes to prove negligence or strict liability in a Maryland dog bite lawsuit, from the owner's duty to control their dog, to what counts as true damages, and how defenses like contributory negligence or assumption of the risk can affect your case. Maryland's laws are strict, and the details definitely matter. Now, if you want to make sure you're protected after any kind of injury, you won't want to miss our next video, What Should I Do After Being Injured in a Truck Accident? It's packed with step-by-step advice you need to protect your case and your rights. Trust me, this is the kind of information you want now, not when it's too late. See you right there.